Getting a family law property arbitration underway is straightforward. Here are the first 4 steps. Number 1, you need to discuss arbitration with the client and also with the other side. For an arbitration to proceed, all the parties have to consent to it. To be able to consent to it, they need to understand the arbitration process. So you need to discuss arbitration with clients early on. Don't leave it until you're in a busy court list or a busy directions hearing online, which is a pressured situation. Don't leave it to that point in time when you explain it to the client for the first time. It'd be hard to explain it to them properly, and your client won't be able to properly consider the option. They'll either say yes to it without properly understanding it, without being committed to it, or they might say no to it reactively just because it's a new idea they've first heard about on a stressful day. So discuss it with clients well before any court date. Similarly, discuss it with the other side well before any court date as well. Second thing you've got to consider is what type of arbitration are you going to engage in? And there's 2 choices. You can firstly do a private arbitration. That can occur where there's no court proceedings at all, but it can also occur where there are court proceedings. Section 10L2 of the Family Law Act says that in a private arbitration, the arbitrator can make a binding arbitral award in respect to the division of property between spouses, de facto and married, spousal maintenance between spouses, and they can also make a super splitting order. The second type of arbitration is court-ordered or court-referred arbitration. You have to have court proceedings to be able to commence a court-ordered arbitration. You file an application for arbitration. That causes the matter to be transferred to the list of the National Arbitration List Judge, Justice Wilson. He runs a directions hearing list every Friday, so he'll then make a formal order for the referral of the matter to arbitration, and will also make any ancillary orders that might help in the efficient running of the matter. Now, Section 10L3 of the Family Law Act says that in a court-ordered arbitration, the arbitrator can make decisions about the division of property, spousal maintenance. It doesn't refer to super splitting. There is one school of thought that says that doesn't really matter because Section 10L3 also says the arbitrator can make a determination about any issues arising from the particular matter. There is an alternative argument, however, that perhaps the arbitrator in a court-ordered arbitration can't make orders for super splitting. So my suggestion is, if the parties want to arbitrate, if you're involved in court proceedings, if it seems possible that either or both parties will be seeking super splitting, then don't ask the court to refer you to arbitration. Don't seek an order for the arbitration. Instead, ask the court to adjourn the matter for a few months for the arbitration to proceed, and you engage in private arbitration. That way there's no uncertainty about exactly what the arbitrator can do, particularly in respect of splitting superannuation. Third step you've got to consider in getting a family law property arbitration underway is what model of arbitration you're going to use. And there's 4 choices here. The first choice is to do an arbitration just off the papers. The parties agree what's the material the arbitrator is going to be reading, affidavits, evidence, written submissions. The arbitrator reads all that material. There's no hearing as such, and they then issue their arbitral award based upon that written material. Time efficient, cost efficient, may well be appropriate where the parties have agreed to some particular issues and there's only a small number of discrete issues for the arbitrator to consider. For example, are you going to sell the house or is someone going to keep it? Are you going to split super, not split super? What might be the overall percentage? The second model of arbitration is a short hearing for the purpose of giving submissions, not cross-examination, just submissions. I think it also provides an opportunity for the clients to be there and to be reassured that the arbitrator does have an understanding and has taken into account what they and their lawyers might think is important. The third model of arbitration is having oral evidence, but it being restricted either to the number of witnesses or the time around the cross-examination, so you can control how long the arbitration is actually going to go for. In many of the arbitrations I've done, there's been sensible agreements around what's going to be the subject of cross-examination, so we can design a hearing plan so we can make sure it gets done in a day. Sometimes we've had to start a bit earlier than a court might start, or go a bit longer, but we can get it done within a day. One of the other advantages of arbitration is that on that day, the only thing in my diary is going to be that arbitration. The only thing in the lawyer's diaries is going to be that arbitration. So we know it's going to proceed on that day. It's a bit different when you go off to court and there's never a guarantee the court's actually going to have a judge available to hear your matter, or your particular judge may have had to have taken on a more urgent matter. So there's more of a guarantee of an arbitration running on the agreed day. The fourth model of arbitration is to have a full hearing where there's no restrictions other than the usual rules of evidence and relevance as to what oral evidence might be given and around cross-examination. In that case, there's not quite so much control about how long the arbitration might go for, and therefore the cost might actually be. Fourth thing you need to consider in getting an arbitration underway is you need to select and engage the arbitrator. For the arbitral award to be binding and enforceable, the arbitrator has to be on one of the two lists kept by AFLAM, the Australian Institute of Family Law Arbitrators and Mediators, and their two lists are one that has those arbitrators who have satisfied the requirements for expertise in family law and have done the AFLAM training. The second list involve arbitrators like me who have also done some studies in arbitration at a university level and have satisfied an assessment process at university level as to their expertise at the arbitration process. You also need to give some thought, of course, to what the arbitrator might be charging in terms of fees and also their availability might actually be. Most arbitrators, if requested, will send to you a summary of how their process normally works, a copy of their standard arbitration agreement, which contains details about fees and also dates. You then have the preliminary conference or the planning meeting for the arbitration, in which the arbitrator will explain to the clients how arbitration works, so the clients can make a final and properly considered decision. Do they really want to arbitrate? Do they really want to arbitrate with this particular arbitrator? The questions about what type of arbitration to use, what model of arbitration is to be used, can be discussed and agreed upon and reflected in the arbitration agreement, along with what evidence might be relied upon, timetable for providing any further information, and a date for the final hearing. It's the signing of that arbitration agreement which gives the arbitrator the authority to conduct the arbitration and to also issue the binding arbitral award and their reasons for that award. So it's on the signing of the arbitration agreement that the arbitration is really underway.